Good morning. Parliament is resumed. I invite the Honourable Deputy Premier to lead us in prayers.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech Thee so to direct and prosper the deliberations of Parliament now assembled, that all things may be ordered upon the best and surest foundations for the glory of Thy name and for the safety, honour, and welfare of the people of these islands. Bless our sovereign King Charles III, William, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of the Cayman Islands, the Premier, the Speaker of Parliament, the Leader of Opposition, Ministers of Cabinet, ex officio members, members of Parliament, the Chief Justice, and the members of the judiciary, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for Thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make His face shine upon us and be gracious unto us. The Lord lift up the light of His countenance upon us and give us peace now and always. Amen.
Please be seated.
Administration of oaths or affirmations.
None.
Readings by the Honourable Speaker of messages and announcements.
I'm very tempted to say something about the weekend's incredible performance of one of our athletes, but I will not steal the minister's thunder.
Presentation of petitions.
None.
Presentations of papers and of reports.
None.
Questions to the Honourable Ministers and members of the Cabinet.
None.
Statements by Honourable Ministers and members of the Cabinet.
I invite the Honourable Minister for Youth and Sport to make his statement.
Thank you, Mr. Speaker. Mr. Speaker, I'll have copies of the statements delivered to the rest of the members of Parliament shortly. Okay. Thank you, sir. Mr. Speaker, I would like to take this opportunity to congratulate our young Caymanian athletes who have just competed in the World Aquatic Swimming Championships in Budapest. These young people have done an exceptional job at representing our beloved isles. Mr. Speaker, I would like to congratulate and recognize Jordan Crooks, Jillian Crooks, and Kira Rebus on a successful and outstanding representation at these championships. Jillian and Kyra both set new national and CI, Cayman Islands Swimming Association's records. Jillian setting a new record in the 100-meter freestyle at the time of 54.13 seconds, and Kyra, who won the 400-meter heat in a time of 4 minutes, 14.77 seconds, and in the 800-meter freestyle with a time of 8 minutes, 46.13 seconds. To Jillian and Kyra, I am delighted to extend our congratulations to both of you for a job well done. We are looking forward to seeing your continued growth in the sport. But on Saturday, the 14th of December, Mr. Speaker, we watched Jordan as he demolished the 50-meter freestyle short course world record not once, but twice. This was in less than 24 hours, sir. Finishing the 50-meter freestyle heat in a record time of 20.08 seconds, and then returned and shattered his own record in the semifinals and becoming the first swimmer in history to go sub-20 in the 50-meter freestyle with a time of 19:90. Then on Sunday, the 15th December, Jordan went on to win gold in the 50-meter freestyle with a time of 20.19. And Mr. Speaker, might I add, that is also the 5th fastest time in this event. Mr. Speaker, it is my great honor to congratulate Jordan Crooks for breaking the world record in the 50-meter short course and also successfully defending his 50-meter freestyle at the World Championships. Throughout his swimming career, Jordan has done an outstanding job at representing the Cayman Islands, whether it be at CRIFTA Swimming Championships, the Central American and Caribbean Swimming Championships, the NatWest Games, the Youth Olympic Games, Junior Pan Am Games, the World Swimming Championships, the FINA World Championships, and the 2024 Olympic Games, where he became the first Caymanian to reach the finals in the men's 50-meter freestyle. Mr. Speaker, Jordan's performance over the years is a testament to his faith, family, drive, talent, and dedication. I am so immensely proud of this young man, not only for his ability to excel in swimming, but also his ability to bring our people together in a show of national pride. It was heartwarming to see persons gathering for watch parties and showing support online for Jordan's win for the Cayman Islands. I know that Jordan will continue striving for excellence and being a role model for younger athletes, not only as our sports ambassador, but also as an individual. And Mr. Speaker, to our community, we invite you to welcome home our athletes on 2:30, Tuesday, 17 December at the Owen Roberts International Airport. And to add, Mr. Speaker, the Cayman Islands government will be hosting an event on Cardinal Avenue on Saturday, the 21st of December, 2024, from 6 p.m. to 8:30 p.m., and we invite you all to attend. Thank you, Mr. Speaker.
Thank you, Honourable Minister. That is truly incredible. Madam Clerk.
Personal explanations,
None.
obituary and other ceremonial speeches,
None.
raising of matters of privileges,
None.
government business, bills, second reading, Children Amendment Bill 2024.
I recognize the Honourable Deputy Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Children's Amendment Bill 2024.
The bill has been duly moved. Does the Honourable Deputy Premier wish to speak thereto?
Yes, Mr. Speaker. Mr. Speaker, I rise to present on behalf of the government a bill to amend the Children's Act 2012 revision. Mr. Speaker, the Children's Amendment Bill is an important step forward in how we protect and support our children and families. The Children Amendment Bill creates a stronger advocacy for the well-being of our children. It establishes the Office of the Commissioner for Children and Young Persons to champion their rights and well-being. It also updates how information is shared within the department to ensure better coordination and quicker responses to children's safety when it's at stake. This bill introduces care plans to provide clearer, more tailored support for children in care, strengthens the rules around children's homes to ensure that they are safe and nurturing, and allows individuals in civil partnerships to take a parental responsibility, reflecting the diverse families in our community and constitutional obligations. It also simplifies the process for transferring a child to secure accommodations and remove outdated provisions from the Principal Act to keep the legislation relevant and effective. Mr. Speaker, these changes are vital because they put the best interest of our children at the center of everything that we do. They ensure our systems are better equipped to meet the real-life needs of children and families in the Cayman Islands, offering them stability, security, and a stronger foundation for the future. As mentioned earlier, in earlier speeches last week in regards to the Older Persons Amendment Bill, I look forward to seeing the vision and the alignment of the needs of the community come to life, not only for the older persons, but also for children and young people in the community-friendly spaces like Central Scranton Park, Mr. Speaker, which you know holds dear to all members of Georgetown. Mr. Speaker, I intend for the youth center within the park to be used for meaningful and impactful programs that will be delivered by entities such as the Department of Children and Family Services and Family Services and relevant nonprofits to meet the needs of children and youth in the Cayman Islands. Mr. Speaker, please allow me this opportunity to recognize a former member of Parliament, the Honorable Frank McField, who's here in the chamber viewing today, as he was instrumental in getting us thus far when it respect to youth of the Cayman Islands. Mr. Speaker, the Children Amendment Bill 2024 will further strengthen legal protections for children, upholding their rights and ensuring necessary safeguards are in place to support them. It also provides necessary regulatory and advocacy frameworks aligning with international best practices such as the United Nations Convention on the Rights of a Child. In 2023-2024, the ministry conducted consultation with key stakeholders, children and youth, persons with lived experiences, the Department of Children and Family Services, and other government entities to ensure that this legislation and the Adoption Bill 2024 is fit for purpose in meeting the needs of the community and the persons we intend to serve and safeguard. Mr. Speaker, the amendment bill seeks to amend the Children Act 2012 revision in 64 clauses. Clause 1, Mr. Speaker, provides for the short title and commencement of the legislation. Clause 2 amends the Principal Act by deleting references throughout the Principal Act to the words Governor and Cabinet and substituting the word Cabinet. Clause 2 also amends the Principal Act by deleting references to Roman numerals in relation to parts and substituting references to the Arabic numerals. Clause 3 amends the Principal Act by repealing the part heading for Part 1 and substituting a new part heading to bring them in line with the drafting style of the legislation in these islands. Part 1 of the Children's Bill has been amended to include the following definitions, Mr. Speaker. 1, neglect. In relation to a child, it means the lack of provision to the child of essential care, including food, clothing, medical care, lodging, and other necessities of life, to the extent of causing or being reasonably likely to cause personal injury or physical pain to or injury to the mental or physical health of the child. Number 2, relevant authority means a public authority or a private entity and includes a nonprofit organization and anybody, whether incorporated or unincorporated, that provides any service under a contract made with the public authority or private entity, the provision of the service being a function of that public authority and private entity. Number 3, young person means a person who is attained the age of 18 years, but who is not yet attained the age of 25 years. Mr. Speaker, Part 1, which is titled Introductory in the Children's Act. The Children Bill includes the following proposed amendments and the insertion of Section 3A, entitled Voice of a Child. This section, which provides for the participation of children in any decision that has an impact on the child's life and the matters to be dealt with when a person has to ascertain the wishes and the feelings of a child for this purpose. The inclusion of Section 3A aligns with the United Nations Convention on the Rights of a Child, to which the Cayman Islands is ratified too. Part 1 also includes proposed amendments to expand those who have parental responsibility at birth to include 1. Where a woman gives birth to a child, known as the mother, and at the time of the birth, the mother is in a civil partnership with another woman. The child's mother and the woman with whom the mother is in a civil partnership at the time of the birth of the child shall each have parental responsibility for the child. 2. Where an adoption order has been made under the proposed Adoption Bill 2024 or the law of any other jurisdiction, each person named in the adoption order shall have parental responsibility for the child who is subject of the adoption. This is in addition to persons that already have parental responsibility for a child at birth, namely the mother, the father, where he and the mother registered the child at birth, or they are married at the time of birth. Persons can also acquire parental responsibility under other provisions under the Child's Act, such as provisions 4A. Part 1 is further amended in relation to Section 9, Mr. Speaker, which amends welfare reports and proposes to allow for the courts to also ask guardian ad litem, in addition to the existing social workers, to complete a report on matters relating to the welfare of the child. Within Part 1, there has been the insertion of Section 9A and 9B, which speaks to the disclosure by officers of the Department of any interest in relation to the exercise of any of the officers' functions and for the confidentiality of information held by the Department, respectively. Clause 12, Mr. Speaker, amends Section 10 of the Principal Act by, among other things, removing the reference to the Affiliation Act, 1995 revision, since much of that legislation has become redundant, and this legislation repeals that act. Clause 16 amends the Principal Act by inserting Section 16, the proposed Section 16A, which provides for the duty of a parent to maintain their children. Part 2 of the Children's Act is entitled Orders with Respect to Children in Family Proceedings, Mr. Speaker. The amendments in this section are primarily to make the provisions general in nature and updating the references to legislation that have been updated since the commencement of this Children's Act. Part 3 of the Children's Act is entitled The Department's Support for Children and Families. The Children's Bill includes the following proposed repeal and substitution to Section 19, which is entitled Provisions of Services for Children in Need, Their Families, and Others. This section notably states that it is a duty of the Department to safeguard and promote the welfare of children who are in need, and so far as it's consistent with that duty, to promote the upbringing of children by their families by providing or facilitating the provision of a range and level of services appropriate to the needs of those children. Under the proposed Section 19, the department can provide the duty stated above by giving assistance in kind in exceptional circumstances in cash where financial assistance is not being provided by any other entity or where additional financial assistance is necessary. Additionally, if a person receives financial assistance from the Department of Financial Assistance, the person is not liable to make any repayment of the financial assistance, except where required in accordance with the Financial Assistance Act, 2022. Within Part 3, Section 20 and 21, which are titled Daycare for Preschool and Other Children, and Review of Provision for Daycare, Children Minding, etc., have been repealed respectively. These sections were never commenced in the Children's Act before. Section 26 of the Children's Act is amended within Part 3 to state that a person who qualifies for advice and assistance means a person within the islands who is under 24 years of age and who was, at the time after receiving the age of 16, but while still a child, A, looked after by the department, B, accommodated in a children's home, or C, accommodated in any residential care home for the consecutive period of at least 3 months, but who is no longer so looked after or accommodated. The above amendment to Section 26 and the Department's ability to provide accommodations for anyone who is at least 16 but is under 24 years of age in a children's home or other accommodations which takes children who have reached the age of 16, if the Department considers that to do so would continue safeguarding and promote the welfare of that person as a part of the aftercare scheme program that the department already provides and the provision currently existing within the Children's Act. However, in the Children Bill, the upper age range has increased from 21 years of age to 24 years of age. Mr. Speaker, Clause 21 amends Section 25 of the Principal Act by, among other things, inserting proposed subsections 4A to 4J and 11, which provides for the matters concerning departmental foster parents, including minimum age of department foster parents and exceptions, the usual fostering limit, and the procedure in which, to the consideration of the representations made by the department about the discharge of its functions relating to the departmental foster parents. The bill has included criteria for the departmental foster parents, which is aligned with the proposed Adoption Bill 2024, which we'll hear later in this Parliament, and applies to someone who is at least 25 years of age. However, Mr. Speaker, the department may place a child with someone who is at least 18 years of age after considering any relevant regulations and ensuring the placement would not prejudice the welfare of the child and would be in the best interest of the child. The department shall enforce a fostering limit for the departmental foster parents, which currently exists in the Children's Act, and that limit is no more than 3 children unless all children placed are siblings, or the department exempts the departmental foster parents from the fostering limit. In determining to exempt someone from the fostering limit, Mr. Speaker, the department has considerations outlined in Section 25(4)D of the Children's Bill 2024. Mr. Speaker, Part 3 has the proposed amendments to repeal repeal and substitute Section 27, which is titled Use of Accommodation for Restricting Liberty. The proposed amendments include aligning with the UK statute to increase the duration of which a court can grant an order which it places a child in accommodation that restricts the liberty and is known as a secure accommodation from 3 months to 6 months, Mr. Speaker. Additionally, no court shall grant secure accommodations unless the child has been legally represented and the child has failed to acquire, or the child has failed to acquire or refuse legal representation, Mr. Speaker. Section 30, within Part 3 of the Children's Act, has been amended to repeal and replace subsections 1 and 2. These provisions speak to the cooperation with the department and allows the department to request the assistance of the public authority or private entity and can specify the actions in their request, including the manner and time in which the action should be taken. The disclosure of information within a request can be exempt if the disclosures involve information that would be privileged from production in legal proceedings on the grounds of legal professional privilege, or if the disclosure would be in contempt of the court. Part 3A of the Children's Act is titled Notification and Investigation of Abuse. The Children's Bill includes the following amendments to Part 3A. In sections 32A2 has been repealed and replaced with the following list of mandatory reporters. The list of mandatory reporters are such, Mr. Speaker. A registered practitioner. B, a police officer. C, an officer of the fire brigade established under Section 3 of the Fire Brigade Act 2006 revision, including any volunteer officers recruited in accordance with that act. D, a probations officer. E, a social worker. F, an officer of the department. G, a minister of religion. H, a person who is an employee of or volunteer with an organization formed for religious and spiritual purposes. I, a teacher, principal, counselor, or other employees in or volunteer with an institution established for the care and education of children. J, a person who provides child care services. And K, any person who is an employee of an entity and being a person who, 1, is engaged in the actual delivery of services to children, or 2, holds a management position in the relevant entity, the duties of which include direct responsibility for or direct supervision of the provision of services to children. And L, a member of parliament. And M, any other person who by virtue of volunteering, 1, volunteering, 2, engaging in community service, or 3, the person's employment or occupation, paid or unpaid, has the responsibility to discharge a duty of care towards a child. Now, Mr. Speaker, you can see the list of reporters are extensive to make sure that anybody who has connectivity with children are protected. The repeal and substitution of Section 32E, which addresses the assessment and investigation of reports by the department, introduces enhanced procedural requirements. Under this section, the department must, within 3 days of receiving a notification and statement of abuse or neglect, assess the information evaluate the situation, and determine whether to refer the notification to the Commissioner of Police for further action or information, or inform the individual responsible for the child's care and custody. However, Mr. Speaker, such communication must be avoided if it risks causing physical or emotional harm or endangering the child's safety. Additionally, Mr. Speaker, Section 32E permits the Department to provide updates to the notifier of abuse if the notifier is a registered practitioner, teacher, principal, counselor, or other employees or volunteers at an institution established for the care and education of children. These updates must be limited to information that aids in the delivering service to the child. Furthermore, Mr. Speaker, the confidentiality provisions regarding the notification of abuse or neglect under Section 32C of the Children's Act are extended in the Children's Bill to encompass individuals who receive updates or share notifications and statements from the Department under Section 32E. The proposed Section 32F provides for certain persons with whom and certain instances in which the Department may share updates and the notifications and statement. The proposed Section 32G introduces critical measures to ensure the protection of children. It mandates that all public authorities and private entities, whether individuals, hold positions outlined in Section 32A2 of the Principal Act, must establish a written policy detailing safeguarding procedures, as well as protocols for reporting child abuse and neglect. Furthermore, Mr. Speaker, these entities are required to provide training to individuals in these positions with a prescribed time frame, reinforcing the commitment to creating a safe and secure environment for our children. The proposed Section 32H provides for restrictions on employment in positions under Section 32A2 of the Principal Act. It is proposed that such persons are to be subject to a prescribed screening process. Part 5 of the Children's Act is entitled Care and Supervision. The Children's Bill includes the following amendments, Mr. Speaker. There is the insertion of Section 35A, which it is titled Care Plans. This section allows for the Department to prepare care plans when they apply to the court for care orders under the existing Section 33 of the Children's Act. The care plans will have corresponding regulations that prescribe the information in the care plan and the plan for future care of the child, which may include expectations. I apologize, Mr. Speaker. Let me read that over. The care plans will have corresponding regulations that prescribe the information in the care plan and the plan for future care of the child, which may include expectations of the parents and of persons with parental responsibility. Part 5 also introduces Sections 38A and 38B, granting the court authority to mandate participation in a treatment program for a party involved in family proceedings in the court determining if the court determines that such participation would enhance the party's involvement in the child's life. Additionally, these sections empower the court to order drug testing for a party connected to the family proceedings when such an order is deemed to be in the best interest of the child. In the insertion of Section 40A, entitled Power to Include Exclusion Requirements in Interim Care Orders, is modeled after the United Kingdom's Children's Act 1989 revision. This section empowers the court to exclude a person from a specific location while an interim care order is in effect, if the court determines that such exclusion would prevent the child from suffering or being likely to suffer significant harm. The Children's Bill has included the insertion of a new part entitled Part 4A, Freeing of a Child for Adoption. This part includes an order freeing a child for adoption. The department can apply for this order when the parent has failed to meet the objectives outlined in a care plan, as specified in Section 35, within the designated time frame, Mr. Speaker. The court may grant the order if it determines that it is in the best interest of the child. This provision, grounded in international precedent, also seeks to address concerns that children remain in foster care without parental engagement, preventing permanency planning due to unreasonable withholding of consent for adoption by parents. Part 4A also includes provisions for the revocation of an order freeing of a child for adoption. If a child has not been adopted or does not have a permanent home with the person they were placed with for adoption after 24 months, the former parent may apply to the court for the revocation of the order. If the court approves the application, the former parent's parental responsibility may be reinstated. Mr. Speaker, I do apologize. I was saying Part 5 before, which I was correct. This is Part 4. Part 4 of the Children's Act, entitled Protection of Children. The Children's Bill includes the following proposed amendments to Part 4. The insertion of Section 46A, which is titled Power to Include Exclusion Requirements in Emergency Protections Order. And this addition is based on United Kingdom's Children's Act 1989 and allows for the court to exclude a person from a place when an emergency protection order is in effect, if the court is satisfied that by excluding that person from the location, the child will no longer suffer or be likely to suffer significant harm. Part 4, subsection 49 of the Children's Act has been replaced and substituted. The new version, titled Removal and Accommodation of Children in Cases of Emergency, expands upon the previous provisions, which only allows the police to remove children in emergency situations, considered as interim emergency protection. However, the previous section lacked a clear process for placing the children after removal, requiring the police to contact the department for placement. The revised provision now permits either a constable or an officer of the department to remove a child to a suitable accommodation or prevent the child's removal from a healthcare facility if it is believed that such an action would cause significant harm to the child. No child should remain in interim emergency protections for longer than 72 hours, Mr. Speaker. Insertion of Section 49A mandated that all entities and public authorities providing services for children or young people must have a written safeguarding policy in place. Additionally, these organizations are required to ensure that their employees undergo training of safeguarding procedures within a prescribed period. Mr. Speaker, Section 50 of the Children's Act has been amended. This section outlines the department's duty to investigate where there is concern that a child is in significant harm or there is an emergency protection order for the child. The amendments of the Children's Bill include repealing and replacing subsections 9 and 10 and introducing subsections 11 to 13. The basis of this amendment is that for the purposes of the department's duty to investigate, Mr. Speaker, the department can request information from the following: A, the Royal Cayman Islands Police Service; B, a public authority; C, an educational institution; D, a healthcare facility; E, a person under Section 32A(2); E, a non-profit organization; F, an organization engaged in the delivery of services to children; G, a youth organization; H, a sports organization; and I, a body or person that provides services in the fields of 1, children protection and child care services; 2, education; and 3, health. The disclosure of information within a request can be exempt if the disclosure involves information that would be privileged from production in legal proceedings on the grounds of legal professional privilege, or if the disclosure would be in contempt of the court. Recovery of abducted children has been amended in the Children's Bill under Section 53 to increase the fine to $30,000 or to imprisonment for a term of 5 years. There is the proposed repeal and substitution of Section 54, which is now titled Abduction of Child by Parent, Persons with Parental Responsibility or Guardian. And this section outlines an offense where a parent or person with parental responsibility for a child or guardian of a child takes or sends a child out of the islands without the appropriate consent of the parent, person with parental responsibility, or the guardian. Part 6 of the Children's Act is titled Community Homes, has been replaced also in the Children's Bill. Part 7 of the Children's Act is titled Voluntary Homes and Voluntary Organizations, and this has been replaced in the Children's Bill. Part 7, Mr. Speaker, these Roman numerals, I can't remember whether Part 7, V111 is 8 or is it 7, but I think it's 7, of the Children's Act is titled Registered Children's Homes, and this has been proposed to be repealed in the Children's Bill. Under the Children's Bill, Part 5A has been inserted and is titled Children's Homes. This part replaces repealed Part 5, 6, and 7. 5, 6, and 7. Got the cue from my team. The Children's Home part was introduced in the Children's Bill to provide one registration process and inspection requirements for all children's homes. The part outlines the registration of children's homes, applications for registration of children's homes, grant or refusal of application, variation or imposition of conditions, imposition of conditions, cancellations of registrations, right to make representation, decision of the Commissioner for Children and Younger Persons, reconsiderations of a decision, as well as the appeal process. The part also speaks to persons disqualified from carrying on or being employed in a children's home. Part 9 of the Children's Act is titled Private Arrangements for Fostering Children, and this has been proposed for repeal in the Children's Bill. Part 10, Mr. Speaker, of the Children's Act is titled Children Minding and Daycare for Young Children, and this has been proposed for repeal in the Children's Bill as well. Part 11 of the Children's Act is titled Governor and Cabinets and Governor's Supervisory Functions and Responsibilities, and the Children's Bill includes the following amendments to Part 11, including the repeal and substitution of the heading to read as Supervisory Functions and Responsibility of the Commissioner of Children and Younger Persons, the Cabinet, and the Governor. So, Mr. Speaker, it's making the alignment with the updated legislations we have to include now the Commissioner of Children. The proposed amendments include inspection of certain premises by the Commissioner for Children and Younger Persons. There is the proposed section insertion of Part 11A of the Children's Bill, which establishes the Office of the Commissioner for Children and Younger Persons, which includes the functions, powers, references to the United Nations Convention on Rights of a Child, involving children and younger persons in the work of the Commissioner for Children and Younger Persons, salaries and emoluments, independents, staff, advisors, youth advisory panel, provision of reports, and other documents. For human resources purposes, it is anticipated that the Commissioner for Children and Young Persons appointment will be under the Public Service Management Act 2018 revision by the Governor. The appointment is to be by the Governor acting after consultation with the Premier and the Leader of Opposition. The Commissioner for Children and Young Persons is accountable to Parliament through the publication of reports and its discharge of functions outlined below in Section 38B of the proposed Children's Bill. The Commissioner for Children and Young Persons will be required to complete strategic plans and annual reports and includes publications and anonymity requirements of reports and plans published. In addition to the above, Part 11A also includes provisions for immunity, indemnity, and regulations. The role of the Commissioner for Children and Young Persons will be dedicated to safeguarding and advocating for children and young persons within the Cayman Islands. The provisions of the Children's Bill propose the function of the Commissioner for Children and Young Persons to include promoting the harmonization, thank you so much, harmonization of legislation and policy within the UNCRC and any other European or international treaties under any conventions protecting the rights of children and younger persons, which extend or apply to the Cayman Islands. The role of the Commissioner of Children and Younger Persons is proposed to also monitor the implementation of these treaties. I would encourage Caymanians to express interest and think of the qualifications in this area as we develop the role of Commissioner for Children and Younger Persons. based on the expected positive impact on the community and underpinning of the foundation and social fabric. This post will have the potential to empower many. Additionally, Mr. Speaker, the Commissioner for Children and Young Persons is proposed to promote the awareness and understanding of rights of children and younger persons through education and promotion. The Commissioner for Children and Young Persons can provide advice and recommendations on the rights of children and young persons. Furthermore, the Commissioner for Children and Young Persons can review services provided for children and young persons, look into or formally investigate any matters relating to the rights of children and young persons, and furthermore, intervene in relation to legal proceedings and complaints against relevant authorities. The proposed legislative framework for the Commissioner for Children and Young Persons has been widely mirrored by the Commissioner for Children and Young Persons Jersey Law 2019 and the Cayman Islands Ombudsman Act 2021 revision. Part 12, Mr. Speaker, of the Children's Act is titled Miscellaneous and General, and the Children Bill includes the following proposed amendments of Part 12, including insertion of Section 995A, which is titled Amendments of Schedules, which allows Cabinet to amend schedules other than Schedule 10 by order in Cabinet, and Cabinet may amend Schedule 10 by order subject to the affirmative resolution. Within Part 12 of the Children's Bill, there is a proposed insertion of Section 93A and 93B, which speaks to the incompatibility of other legislation and also protection from liability for disclosures made pursuant to this Act, respectively, Mr. Speaker. The incompatibility of other legislation is that no enactment or law prohibiting or restricting the disclosure of information shall stop a person from furnishing the Department with any information required for the disclosure of the duties of the Department under this Act. Furthermore, Mr. Speaker, a person who discloses information as a requirement of the Children's Bill and has acted in good faith shall not under any order, shall not incur any civil or criminal liability or be liable in disciplinary proceedings for the disclosure. Throughout the Children's Bill, there has been the removal of governor and cabinet and replaced with cabinet. Throughout the Children's Bill, there has also been removal of references to him and references to make the provision gender neutral where applicable. Furthermore, Mr. Speaker, where there is a reference to married in the Children's Act, the Children's Bill has been amended to include the words or in a civil partnership. There are 10 schedules in the Children's Act. The following schedules have been proposed for amendments or repeal in the Children's Bill. Schedule 1, which is titled Financial Provisions for Children, has been amended in the Children's Bill to propose that where there is an existing order under the Children's Act for payment of monies for the benefit of a child and that child enters the care of the department responsible for ensuring that the payments are received in respect of the child in accordance with the existing order, and the courts may direct that the payments shall be made to that department for the benefit of the child. Schedule 1 is also amended by removing the specific maximum amount of lump sum which may be ordered by the court under an order for financial relief. This schedule is also incorporates the relevant provisions of the Maintenance Act, Mr. Speaker, that relates to the children in the order to have the framework under one legislation, and hence the Maintenance Amendment Bill that is before this Honorable House 2024, that is also being brought forward. As mentioned earlier in my statement regarding the Department of Financial Assistance, one of the changes to the policy is that no parent with children who applies for financial assistance should be made to seek maintenance in order to receive financial assistance. Once further options for the government to, apologize, Mr. Speaker. Once further options for the government to seek maintenance on behalf of parents have been researched and presented, I anticipate that changes to this schedule will be forthcoming and made by Cabinet through an order. Schedule 2, Mr. Speaker, which is titled Department's Support for Children and Families, have been amended in the Children's Bill in paragraph 6 by proposing the repeal of the existing paragraph 6 and substituting that the department shall provide services to children with disabilities which are designed to minimize the effects of the disabilities of those children and to give those children the opportunity to lead their lives on an equal basis as persons without disabilities. Schedule 3, Mr. Speaker, which is titled Supervision Order, has been amended in the Children's Bill and proposes an increase to the fine in paragraph 17, which refers to where there is an education supervision order in force and a parent of a child persistently fails to comply with the order, commits an offense under this paragraph, is liable to a summary conviction, to a fine of $5,000, or to imprisonment for a term of 6 months, or both. In the Children's Bill, Mr. Speaker, there is the proposed insertion of Schedules 3A and 3B. Schedule 3A is titled Matters Not Subject to Investigation by the Commissioner of Children and Younger Persons, and Schedules 3B is titled Advisory Panel. The matters not subject to investigation by the Commissioner for Children and Young Persons include action taken in matters certified by the Governor to affect relations or dealings between the government and any other government or any international organization of states or governments. Action taken in matters certified by the Governor to affect defense, external affairs, and international security, the commencement or conduct of civil or criminal proceedings before any court of law in these islands, legal advice given by or on behalf of the Attorney General or the Director of Public Prosecutions to the government or to any public body, and any action which, by virtue of the Constitution, may not be required into by any court, to name a few. Mr. Speaker, that is an outline as to how far the Commissioner can go in her or his powers. I don't know why, but in my mind I see the Commissioner of Children and Younger Persons to be a her. I hope it is. Women have a special way of caring for the future. The advisory panel will be made up of 6 persons aged 13 to 24 who will be cabinet appointed and will consist of A person from the District of Bordentown in Grand Cayman, B, 1 person from the District of East End in Grand Cayman, C, 1 person from the District of Georgetown in Grand Cayman, D, 1 person from the District of Northside in Grand Cayman, E, 1 person from the District of West Bay in Grand Cayman, and F, 1 person from Cayman Brac or Little Cayman. Schedule 10 is titled Amendments, Transitional Provisions, Savings, and Repeals. And transitional provisions have been proposed for the Commissioner for Children and Young Persons in such that the Governor may make any transitional arrangements for the appointment of the first Commissioner for Children and Younger Persons as may be appropriate for the establishment of the Office of the Commissioner for Office of Commissioner for Children and Young Persons. Additionally, there are proposed transitional provisions for privately fostered children as a result of the repeal of this section and children's homes as a result of the introduction of this registration process. Schedule 4, titled Management and Conduct of Community Homes, is proposed for repeal. Section 5, titled Voluntary Home and Voluntary Organizations, is proposed for repeal. Schedule 6, Registered Children's Homes, have been proposed for repeal. Schedule 7, titled Foster Parents, Limits on Numbers of Foster Children, is proposed for repeal. Schedule 8, titled Privately Fostered Children, is proposed for repeal. And Schedule 9, titled Child Minding and Daycare for Young Children, is proposed for repeal. Mr. Speaker, it is important that I reiterate, just in case somebody misses the whole debate, that all these areas, though they're being repealed, have been addressed in other subsequent amendments. The following regulations have been proposed for repeal. 1, the Children Private Foster Care Regulations 2012. 2, the Community Homes Regulations 2012. 3, the Disqualification from Providing Private Foster Care Regulations 2012. 4, the Emergency Protection Order Transfer of Responsibilities Regulations 2012. 5, the Refugees, Children's Home and Foster Placement Regulations 2012. And 6, the Voluntary Homes Regulations 2012. Mr. Speaker, that outlines the very comprehensive Children's Amendment Bill and the various clauses, substitutions, and repeals. Mr. Speaker, on behalf of the government, I am very grateful for the hard work of the team, as well as the former minister, in developing and consolidating and bringing up to more modern standards the regulatory framework around children, and particularly the Children's Amendment Bill. And I invite all members to support this bill, entitled the Children's Amendment Bill 2024, and I look forward to their full support. Thank you, Mr. Speaker.
Does any other member wish to speak? The Honourable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make a few short comments on the Children Amendment Bill 2024 and to offer the support of the official opposition. Mr. Speaker, I want to also commend all involved in updating this very important bill. The task of safeguarding and protecting the child or every young person from harm, abuse, neglect, or maltreatment, or to prevent harm to the health or development of that child or that young person is a tremendous task and one that has to be taken on by the entire country. We often talk about or use the term, it takes a village to raise a child, and unfortunately those villages are slowly disappearing within our communities. There was a time where you didn't have to worry about getting a nanny or having a helper because you had an entire family around you to help you. You had grandparents, aunts, cousins, everyone chipped in to help raise that child, or to look out as a community, we would always look out for the safeguard and the protection of that child or that young person. We all tell the stories of when we do something bad and someone sees it, we were more worried. Well, we would be punished right there on the spot by an older person if they caught you. And then if you ran from them and didn't plead to, take your punishment there, and for them to not tell your parents when you got home, you got an even worse punishment. And there was no questions asked about it. Mr. Speaker, I just have a couple of short comments and perhaps some questions, and I do realize that the Honorable Deputy Premier and the Minister has only been in the position for a few short weeks. And so perhaps not looking for a response from him, but I know that the ministry is here as well, and just some points that could be maybe extracted from my comments. Mr. Speaker, I am encouraged by some of the amendments I saw in Section 22. And I just want to talk, when we're talking about care homes and stuff, I don't know if it is still the position or still the issue where if a child is in between a scenario where full-time care or adoption is required and getting in trouble legally, to then be either hopefully sent to the Bonaventure or one of the children's homes, and not up to I think it's called Eagle House still, is it? It used to be my understanding, Mr. Speaker, that there was a small gap there. Those kids who were not qualified or not in a situation where they have no parental guidance whatsoever, so they enter into the care homes or orphanage or whatever, but they aren't at the point yet where they're before the courts, and it almost, as I spoke about in a debate last week, where the child would have to enter into the judicial system and almost criminalized to go to one of the homes. And I don't know if, just reading the amendments, whether these care homes and the ability, I saw in the amendment, the ability for the courts ability for the government to arrange a care home for a child while waiting on a court order. And that gave me some hope that this actually applies to those kids who fall in that little gray area between getting in trouble with the law and not getting the care and supervision that they require at home. And we always talk about early intervention. I know that there are kids that enter into that program early, but there are some that as they go through their teenage years, there may be changes in the family, whether it's a divorce or the beginning of abuse of some sorts, or just simply a teenager going through what all teenagers go through and find themselves on a wayward path. That is the sort of early intervention I'm looking for. That might be midterm intervention versus early intervention. Also, Mr. Speaker, I think in the same vein, one of the things when we did our review on the housing needs for the country, and I think the member from Bordentown West, I think, was speaking about this on the radio this morning. One of the things that were identified that was needed was, for lack of a better word, a safe house for those kids who are between the care homes, I guess we call them now, and going back and entering into the real world. If adoption did not happen during their period of time in the care homes, when they are now at an age that they're no longer, the government is no longer responsible, or perhaps the care home is saying, listen, I can't, this young man, this young lady needs to go out on their own. And there was a discussion, what was what we discussed there was a semi-care facility, like a dormitory. It was one of the things that we wanted to put out to private sector to see if anyone would build it. And you could actually, because we were talking about last week we were talking about how do we enforce the fishing license, and it came to me, well, Joey, I keep thinking about the size of government, adding, hiring people, but you could actually, with the fishing license, not going off debate here, Mr. Speaker, but a suggestion would be to deputize persons, private sector. Just like how we have special constables, we could have special constables for Department of Environment. And that way we could do a stipend to cover gas and that sort of stuff, but at least they're not going into government, it's not payroll, it's not ballooning the size of the civil service. But with this halfway home, or this transition home, we could do the same thing, put it out to one of the care services. But this would be a dormitory style place with cameras in the public areas, coded to get into, and you would actually have a caretaker check in on them in the morning and check in on them in the evening or periodically through the day. Just to ensure that there are no guests, no visitors, and that everyone is abiding by the rules. And you give that child when they reach 18, 17 or 18, perhaps even they might be living in their parents' home, but they need to get out of there for various reasons. And they're just starting to work, or they're in an internship program at Public Works, or you need, and they just need somewhere to stay safe while they make that transition. And while they're in there, they should have access to counseling, to career planning, all of these things while they're in this transitional home. So just a recommendation, and I don't know if that's something that needs to go into the I don't think it actually needs to go into the act, but perhaps may need to go into the regulations to make provisions for that. Mr. Speaker, the final part I'm happy to see in here is that actually I want to go back just a quick second. When it comes to the care homes and those persons I spoke about that are in that gray area, I also think there should be, and I don't know if there is, maybe they can let me know, there should be provisions in there for parents to have to cover the costs. That's in there? Okay, great. So the last thing, Mr. Speaker, before I wind up here is what I'm happy to see, Clause 44, Section 54, dealing with the abduction of children by parents or persons with responsibility or guardians. This is something that as a representative you come by way too often, especially in Cayman's community where we are so multinational and in a sense transient. And you have, out of the blue, a parent taking the child on vacation and then not coming back. And all of these sorts of things. And I'm happy to see that they've strengthened the rules on this. And there's a fine of $30,000, not up to, it reads clearly, a fine of $30,000 or a term of 5 years, not up to 5 years, or a term of 5 years, or both. And I'm encouraged to see these new fines and penalties in there for the abduction of a child, because it is happening way too often. So with those few words, Mr. Speaker, I'd like to offer my support on this Children's Amendment Bill 2024 and the official opposition. Thank you.
The Honourable Member for West Bay West.
Thank you very much, Mr. Speaker. Since I saw the bill and knew the bill was being worked on, I had to think back and sat here today doing the same thing, just how much the world has changed, and with the change much, especially with the onslaught of technology and these things called smartphones. Mr. Speaker, how much it has changed since I moved the bill, I think in 1994. Myself and Ms. Seymour, who was a permanent secretary at the time. And back then, Cayman had begun to change. The world has changed, and Cayman is changing with it. The things that, as I said a couple of days ago, that impact large communities in metropolitan countries are impacting Cayman today. Because for several reasons. One, as I said, is the technology, and one is the various cultures that are within our borders. Changes. And there is much for us to do besides the administrative measures that needs to be done. Administrative measures needs to be done. But there's much else to be done. There's need to keep children and young people safe online. And every child seems like has an iPad or one of the smartphones, and they're smarter than us. Those children are smarter than us. They know how, they know if you're watching them, but don't think they don't have inquiring minds. They do. And it's not all good that they find themselves in. And so parents, they have to work with parents. The programs need to be put in place where we are working with parents and other carers to gain the skills and confidence that parents need to help keep children safe online, and that they can respond appropriately to any concerns. So I think from what I've been reading, there are many avenues online for safety training that could be developed in association with education. The various other child protection units that we may have could easily help parents. Now, some parents might not be able to go online. So that's where government comes in and to work with it. Don't think that is a joke. Parents, you have to, and I raised 2 children, and of course, loads of children in the community, and 5 grandchildren I have now. Some of them up in their 20s, 2 of them. And you work. You listen to the older parents, your parents, their grandparents, and you have help from that avenue. But most of them are gone now too. And so we took it on by trial and error sometimes. Sometimes you may have thought you were doing the right thing, and when you found out, the child wasn't being helped at all. So there is much, as I said, that needs to be done besides the various things that's going to make child care from a governmental standpoint better. There is new and I would say emerging online harmful situations, sex and relationships online, and online bullying. That's one of the biggest things that we have to deal with as a growing country. Because some people believe that they can say anything, they can write anything, they don't care if they lie, if they can just get somebody to listen and sell something. So, what do the children learn? And what do the parents learn most of all? And I believe that there are things that we can do to develop a better understanding about how children use the internet and technology and the new and emerging online harms about sex and relationships online, keeping children safe from sexual abuse online, the risks children may encounter online, harmful content online, online radicalization and extremism. That's happening. Where they're learning that, oh, God might have been born, or Jesus might have been born a woman. Can you believe? That's the stuff that's online. And worse is the idea that they want to impregnate here. That a boy was born to be a girl, and a girl was born to be a boy. And they're trying to put that in our children's mind. And some people are buying it. That's the thing that bothers me. What else bothers me is this sharing of personal content and nudes. As I said earlier, bullying online. So we have a lot that we need to do as a community in supporting parents and the carers of children. And I believe we can do some of this from a community standpoint. Be able to have parental research. Parents can understand how the online world can impact children and young people positively and negatively. And we can identify the ways children and young people communicate and interact online. And I'm hard on that this morning because I've seen so many things over the last couple of months and last couple of years. You have to wonder, where do people think? How they have so much time to sit down and write some of the stuff that I see. The foolishness, when it was not made for that. It was supposed to be something educational. This highway that Reagan talked about. The internet. And now we have it. As I said, a changing Cayman for many reasons. We need to look at the various programs from a community standpoint that can help parents, and again, repeat, can help parents and caregivers for children to better understand what is happening. Because some of the parents are not, maybe they don't have the time, but we need to help them to understand they have to take the time, because it's not all about providing a meal. You have to do that. But it's not all about buying a pair of sneakers or spending a load on the most fancy clothes. It's much more than that, and you need to take time in this world that is shaping up the way I see it. Mr. Speaker, I could go on. As I said, I had the responsibility twice to bring firstly the bill and then for the amendment in 2012, because that would have been 8 years, and times changed then, much less from then till now. And we're just getting a comprehensive, I hope, law, amendments to the law that will address some of the newfound and hard things that young people and children are facing right here today. A lot of things not happening by deceit online. Thank you, Mr. Speaker.
Does any other member wish to speak? The Honourable Member for West Bay Central.
Thank you, Mr. Speaker. Mr. Speaker, I rise to contribute to the Children Amendment Bill. As we've all spoken this morning, this is a very important bill. The bill enhances the protection of children in our country and introduces stronger measures that ensures child protection laws are better aligned with international best practices. This bill represents a major step forward in our commitment to protecting and safeguarding the welfare of our children, ensuring that we uphold their rights. More specifically, the bill amends the Children Act 2012 revision, and amongst other things, it clarifies the process for transferring a child to secure accommodation, introduces care plans, and introduces new provisions regarding children's homes. The bill also increases fines and penalties for certain offenses to strengthen effectiveness and act as a deterrent. Two other important aspects of the bill amends the disclosure and information sharing provisions relating to the Department of Children and Family Services and establishes the Office of the Commissioner for Children and Young Persons. I would like to point out that in the bill, young persons is defined as persons between the ages of 18 to 24. While they may not represent the largest voting group, persons 18 to 24 are an underserved group in our society. And I thank the former minister for this innovation to specifically include them during this pivotal period of transition in their young lives. We do recognize the challenges that this group faces, and we remain committed to supporting them. As proof of this commitment, I'm pleased to say that the former Minister for Social Development has confirmed that he will show up and participate in the upcoming Youth-Led Candidate Forum, a forum organized by young persons in this very age group, 18 to 25, who care enough about what is going on to organize an event so that young persons can hear firsthand from candidates in the upcoming election. These students are organizing this event while they're all busy preparing for exams, while they're overseas preparing for year-end and finishing up their term papers. So they're watching us and paying close attention. And although I'm unable to attend due to previous commitments, I'd like to take this opportunity to personally thank these young people for their commitment, their maturity, and professional engagement in matters of national importance. Returning to the bill, Mr. Speaker, it also includes a range of enhanced powers that can be exercised by the court to safeguard children, and also introduces an advisory panel specifically to examine and advise on children and young persons. I would like to take a moment to thank the Honorable Deputy Premier and present Minister of Social Development for bringing this bill forward for debate. I would also like to thank the former minister for the outstanding work done over 2 years, work that is innovative and forward-thinking and shows the world that we are serious about protecting and safeguarding our children. I would also like to take this opportunity to thank the hard-working staff of the Ministry of Social Development. Over the past couple of years, whether working in West Bay or more recently while receiving presentations in caucus, the former minister would often say how impressed he was with the acumen, dedication, and professionalism of the ministry team led by Chief Officer Tamara Ebanks, who worked in coordination with the knowledge, experienced, and hard-working staff of the Department of Children and Family Service led by Ms. Paulinda Mendoza Williams. And last, but certainly by no means least, as someone who has previously worked in the Attorney General's chambers, I witnessed firsthand the amount of work and unique legal skills are required of the legislative drafting team, and they too deserve our appreciation for their contributions to this and all bills presented here in Parliament. In conclusion, Mr. Speaker, the Cayman Islands Children Amendment Bill 2024 is a statement of our values and approach to protecting our children. It demonstrates our unwavering commitment to safeguarding the rights of every child in our society. We're called upon as members of Parliament to be the protectors of our future, to ensure that every child has the opportunity to grow up in the Cayman Islands where they feel safe, valued, and supported. In passing of this bill, we're making a strong and necessary statement that the children of the Cayman Islands deserve our best efforts to create a future in which they can thrive. We are ensuring that we take every possible measure to protect their well-being, to empower their voices, and to provide them with the tools they need to succeed. I urge all members of this House to support the Cayman Islands Children Amendment Bill 2024. Let us unite in this important cause for the protection and advancement of our children and young persons who are the future of our country. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The honorable member for West Bay South.
Good afternoon. Thank you, Mr. Speaker. I rise to contribute to the debate on the Children Amendment Bill 2024. I start, Mr. Speaker, with a quote from former U.S. President Franklin Delano Roosevelt. Quote, "We may not be able to prepare the future for our children, but we can at least prepare our children for the future." Out of all of the social development bills that are put forward for debate in this House, in this meeting, this one for me has slightly more special meaning. Although the work was hard but enjoyable, there are countless hours, Mr. Speaker, with the team to set the strategy, develop policy objectives and priorities, and keep the legislation at pace so that it could be done before the end of 2024. Because the Principal Act is a massive piece of legislation. And it hasn't received any material enhancement since 2012. And I look over the bill and think of the major enhancements that were outlined by the Deputy Premier. The bill is extensive. It took, as it should, the Deputy Premier significant amount of time to outline the clauses of the bill. The major advances in terms of the increase of fines and penalties to give effectiveness to the legislation, to act as a deterrent to protect our children. The groundbreaking, historic office of a Children Commissioner, and having care plans and enhanced provisions for children's homes and secure accommodations is needed, Mr. Speaker. But it hits home for me because out of all the pieces of legislation, this one took me back to my own childhood when we were designing it. Being raised by my father and mother in Brooklyn, New York in the late 70s and 80s. The living was hard. New York was far from safe. The streets were cold and mean. and I saw the effects of children firsthand who lived in substandard accommodation with a range of social challenges, and how easy it is to go off track. For my sister and I, we had the gift of two hardworking parents who were immigrants, to take themselves from lower economic tiers to try to get to the middle economic tier. But when I look upon the need for this legislation, not everyone has that safety net at home. And in a way, Mr. Speaker, it's somewhat sad that Cayman has come to this, because I remember traveling back and forth from stateside to Cayman to visit family when I was younger. And life seemed so much slower and easier. Doors were open. Windows were open. People came and go as they pleased. You don't have to worry. Leaving here today, I have to set my house alarm. And never would I imagine the crime that you're exposed to as back as the 70s and 80s in New York would emerge here in Cayman. The shooting at Ed Bush Field of someone going into a crowd and firing indiscriminately is almost unbelievable. And that's why we need these interventions to try to catch young people before they turn to hardened crimes. That's why this legislation has to keep pace. And still there must be more work to be done. It burns on the inside that the amount of wealth that's in this country, Mr. Speaker, that we need a food bank. And even that food bank struggles to meet its demands. So I urge all members that we vote in favor of this legislation. Overall, out of all the provisions that were outlined by the Deputy Premier, what we're really saying here is we're trying to give our children and young people a fighting chance when they don't have that social safety net at home, to help them meet their max potential. And Mr. Speaker, the member for West Bay West talked about the advent of social media, the speed of information, what children are able to absorb, unguarded. That's another area that will have to be tackled. But, Mr. Speaker, not just the passage of this legislation is, I think, our duty here today. In the same vein of knowing that the children and young persons are watching us, we also, as we carry this legislation through the passage, and they are either watching us now or in the future, will also watch our conduct between each other. This debate seems squarely focused on the children and young persons where it should be. And yes, we know there'll be sharp exchanges that are expected for policy views, current affairs. We've sat in youth parliament and seen them give some fantastic zingers, as they should. That's democracy. But we should aim as much as possible at all times as legislators that they're looking up to. Make sure facts and figures are right. We don't delve into personal areas. They don't see Caymanians tearing each other down outside of policy and democracy. We should be proud of what each other has accomplished in all of our capacities. We should explain that when anyone comes forward, particularly in social development, for supplementary funding, it's not because of what they want. It's because of what essential services need to be provided for our people when there are budget shortfalls. So, Mr. Speaker, let us show our children and young persons that above all, we'll utilize this House for the higher objective it is meant to pursue: to protect and defend our people and solve problems, and not interpersonal with each other. And a strong example of that, Mr. Speaker, is working across the aisle, which we'll come to as members would have seen a notice of a committee stage amendment, to try to improve this legislation even further, to allow for restitution payments to be paid to the surviving guardian of a child whose parent has lost their life due to certain acts, criminal acts of a person. The Deputy Premier and he saw the initial committee stage amendment, saw the purpose of it, what it means to the Grant family and others, where Shemaiah Grant was struck down by a drunk driver. Where do the surviving guardians who are grandparents get the money to continue to help his children? If they're making a particular income level, then they can't apply for financial assistance. Who helps them when it's no fault of their own? Because we've said it many times in this House, reckless driving and drunk driving in this country is out of hand. We're turning cars into weapons. That's what you're doing. So when all of us, I'm sure we've experienced it, somebody zipped by you and you doing 40 and they move past you like you're not even moving. That is a weapon. We got 3-lane roundabouts now and you got people making a right from the left lane. And then a right from the left lane. Crossing all over traffic, stopping cars in the middle of the roundabout. We have to figure out more and more ways to deter people that this is not acceptable. And if you're not going to do it, and it is a weapon, and you take someone's parent from them, then you're going to have to make restitution. It's not fair to our families. So for the Deputy Premier to see the value of it, take my feeble attempts at legislative drafting, give it to the legislative drafters to make the enhancement and bring it in line with standard. I'll get into a committee stage, but my sole purpose was to try to make Michelle Neblett proud. I was actually listening to her at all her drafting sessions. So nervous about it, I even had a few typos that I normally wouldn't have because I was so focused on the actual legislation. But I thank the Deputy Premier for that work across the aisle, for that higher purpose that I mentioned, Mr. Speaker, that we're meant to serve. One last point, Mr. Speaker, just to bookend a conversation that was in the Older Persons Act that I want to say here, is that vacant lot of adult safeguarding. So we've upgraded and hopefully will pass by the end of this day, older persons, children, but nothing is on the books in between for adult safeguarding. And I'm so happy that the Deputy Premier and his roundup of all the ministry staff in the older persons bill that he mentioned, Deborah Webb Sibley's, who I call as Miss Debbie, and also Rail Roberts, because they were part of the mission at the beginning. Miss Debbie's work in older persons is well known and well documented. But what might not be known is the amount of passion she also put into the subject area of adult safeguarding. She wrote me one long 10-pound email to say, we've got to get to this gap. There's only so much you can do in a term. You have to pick your battles. You got to bite down on your priorities and try to get to them, because you try to do everything, then maybe nothing happens. So, Miss Debbie, I heard you. I think the House has heard you. And just to bookend it here, that's something, a cause that I hope gets tackled in the next administration. With that, Mr. Speaker, it's just left for me to thank the government and the Deputy Premier in particular for moving this massive step forward of this legislation. That it's not politics, it's our people, it's our future. Close with former U.S. President Lincoln. Teach the children so it will not be necessary to train the adults. Thank you, Mr. Speaker.
Does any other member wish to speak? The Honorable Deputy Governor.
Mr. Speaker, thank you. I will be brief. Mr. Speaker, I want to thank the Deputy Premier for bringing this bill and the government, and also the former Deputy Premier for the work that has been done. Mr. Speaker, one of my roles and responsibilities in the civil service is to chair the Child Safeguarding Board. It is a board that is charged with overseeing the safety and welfare of our children. We have the police, we have education, we have social development ministry, we have Ministry for Youth, we have the Ministry of Health, all coming together to look at how best we can keep our young people safe. I want to go on record and thank Ms. Satonya Cacho in my office, who has been leading on this initiative and doing a great work. I want to recognize all members of the Safeguarding Board for the amount of work that they've put in to make sure that our children are well taken care of. Mr. Speaker, we're doing so much. The government has invested millions of dollars in the welfare of our children. Our Minister of Education, we all know her passion for her students. During her time, we have employed more counselors, more persons to deal with our special needs students than ever before. Our team in the Department of Children and Family Services has put in intervention programs to deal with our children who are at risk, who find themselves before our justice system. The team in the Ministry of Youth is working closely with our young people. The Proud of Them initiative, I think, is an amazing initiative. It highlights and shows our young people that there are some outstanding members of our community who are doing some amazing things as young people in this country. Because, you know, the old adage is that they are our future. That's not just words, it is the truth. So, Mr. Speaker, is all that we're doing working? Mr. Speaker, I had a look at the compendium of statistics that was published recently, and I had a look at our population over the last 12 years. I think we have grown by over about 47%. I looked at juvenile crime and what has happened with juvenile crime in our country. Mr. Speaker, I am pleased to say that juvenile crime in our country, despite the rise in population, is on the decrease. I hope I have my figures right. Please forgive me if I don't, but this is something that I pay attention to. In 2011, and again, Mr. Speaker, I'm speaking from memory, approximately 70 young people were before our courts for juvenile crime. In 2023, that number was in the 20s, low 20s. I think the percentage was over 70% decrease in young people before our courts. And the majority of those persons were there for traffic offenses, not serious crime. So, Mr. Speaker, what it's telling me is that the work that the civil service is doing the investment that the government has made, the joined-up approach with all of us working together, we are seeing some tangible results. But I said that to one of my team members, and I talked about the reduction in juvenile crime. And their response was, yes, Deputy Governor, we see that. But there's also, unfortunately, an increase in suicides. There's also an increase in attempted suicides by our young people. So, Mr. Speaker, this bill cannot be more timely. The time is now for us to continue to pivot, to be creative, to do everything possible to look after our children. Mr. Speaker, I want to mention just one aspect of the bill, or highlight one aspect of the bill, and that is the appointment of the Commissioner for Children and Young Persons. Mr. Speaker, I believe that just this one part of the bill can be a game changer in our beloved Cayman Islands. Because right now, if I say to my team, who is responsible for the welfare of our children? There's a number of agencies, but there's not one person, one individual overall that has that responsibility. If I say, who is responsible for ensuring that there's no maladministration in the civil service, somebody's going to say, it's the ombudsman. If I say, who is responsible for prosecutions, you're going to say the DPP. If you're going to ask who is responsible for police and crime, you're going to say the Commissioner of Police. Now, we're going to be able to say who is responsible for overseeing the welfare of our children, and it's going to be the Commissioner of Children and Young Persons. That means that this person, who is independent of the civil service, they are a watchdog, like the Auditor General, that they can oversee what's going on in the civil service. So their job, Mr. Speaker, is to hold myself and my team of civil servants accountable. And I welcome that, Mr. Speaker, because it is the right thing to do, to have someone steps away from the everyday work of the amazing team that is looking at children right now. Step back and look and say, are you doing these things correctly? Are you doing them timely? Is what you're doing actually working? And I think, Mr. Speaker, we have put the responsibilities and the functions of the office, I think, are excellent. I've read through them. There are a number of things there that I think is going to make the Commissioner of Office work exceptionally well. There's one thing that the AG and I spoke about earlier that I think we may need to tweak, but I'll bring that to the attention of the DP. But, Mr. Speaker, today is a great day for our children. And, Deputy Premier, thank you for championing this. Former Minister, thank you. To the amazing team over here, thank you. The team in Social Development, the team in the Department of Children and Family Services, the team in the Ministry of Health, our educators, Mr. Speaker, who do a really great job of looking after our children, reporting incidents of needs for child safeguarding. The majority of our complaints or investigations start with teachers. The work that they do cannot go unnoticed, Mr. Speaker. The work of the police, the work of our MASH unit, the work of the Ministry of Youth. I thank everyone for all that they do to make our children's life a bit better, and I thank the government for bringing this bill. I thank you, Mr. Speaker.
Honorable members, before we actually have lunch, we have a treat which we've had for the last 3 or 4 years. We are going to be regaled with Christmas carols by a number of school children who are waiting on us in the lobby. So I will now take the luncheon suspension, and before we head to the dining room, can we all go into the lobby and enjoy Christmas carols by our school children.